A massive Supreme Court decision just dropped, and it is sending shockwaves through every police department in America. If you are a gun owner, if you carry for self-defense, or if you simply value your constitutional rights, you need to stop what you are doing right now and pay close attention, because this ruling changes everything about how you carry, how you interact with law enforcement, and how the legal system will judge you if something goes wrong during a traffic stop. We are talking about a unanimous 9-0 ruling in a city as divided as Washington, D.C., getting all 9 justices, from the most staunch conservatives to the most committed liberals, to agree on anything is like catching lightning in a bottle. But on May 15, 2025, the Supreme Court did exactly that in the case of Barnes versus Felix. 9 justices, 0 disagreement, and the implications reach into every state, every traffic stop, and every holster in this country. This is not just a dry legal update. This ruling fundamentally rewrites the rules for how the Fourth Amendment, your constitutional protection against unreasonable searches and seizures, interacts with your Second Amendment right to bear arms. For decades, a dangerous legal loophole existed in several parts of this country, a rule that essentially gave the government an invisible shield whenever things went wrong during a traffic stop, a rule that erased everything an officer did wrong, every bad command, every illegal escalation, every reckless decision, and allowed courts to judge an entire encounter based on nothing more than a single split second. That shield just shattered, and what replaces it could literally save your life. To understand why this is a victory for every law-abiding gun owner in America, you first have to understand the villain of this story, the legal doctrine that made this ruling necessary in the first place. It was called the moment of threat rule. And if you have never heard of it, that is exactly the problem. Under the moment of threat doctrine, if a police officer shot a citizen, courts in several federal circuits, including the powerful Fifth Circuit, were legally required to put on chronological blinders. They were told they could only look at the split second the trigger was pulled. Everything that happened before that moment, the officer's mistakes, the illegal stop, the aggressive escalation, the contradictory commands, the chaos the officer created, was legally erased. It simply did not exist as far as the court was concerned. Think about what that means in practice. Imagine you are driving home from work. You are legally carrying your sidearm. An officer pulls you over for something minor, a toll violation, a broken taillight, a rolling stop. The officer is nervous. He begins screaming contradictory orders. "Show me your hands! Now get your ID! Don't move! Reach for your wallet!" You are confused. You are trying to comply. Your hand moves toward your pocket to get your license as ordered. The officer sees your holster, panics, and fires. Under the old moment of threat rule, the court would ignore every second of chaos the officer created. They would ignore the contradictory commands. They would ignore the escalation. They would only look at the half second where your hand moved near your gun, ask whether the officer was scared in that instant, and if the answer was yes, case dismissed. Your life, your rights, your compliance, none of it mattered. That is what the Supreme Court just called fundamentally unconstitutional. The facts of the case that changed everything are chilling, and you need to know them. In 2016, a man named Ashtian Barnes was pulled over by a constable named Roberto Felix for a simple toll violation. Not a violent crime, not a felony, a toll violation. The stop started routine enough, but it escalated in a heartbeat. Felix ordered Barnes to pop the trunk. Barnes complied, but Barnes also restarted his car. Perhaps out of nerves, perhaps by accident. Instead of staying back, maintaining distance, and calling for backup the way training manuals explicitly instruct, Felix made a decision that would end a man's life. He jumped onto the doorsill of the moving vehicle. He was literally hanging off the side of a moving car. He had placed himself in that position by his own choice, violating every principle of tactical training that exists. And in that state of entirely self-created danger, Felix fired 2 shots, killing Ashtian Barnes. When the Barnes family sued, the lower courts reached for the moment of threat rule like a security blanket. They said the second Felix fired, he was hanging off a moving car, he was in danger, therefore the shooting was reasonable. They refused, legally refused, to look at the fact that the officer had created that danger himself by jumping on the car in the first place. The family appealed. The case climbed. And eventually, 9 justices of the United States Supreme Court looked at what those lower courts did and said, enough. Writing for the unanimous court, Justice Elena Kagan did something remarkable. She did not just say that courts are allowed to look at events leading up to a shooting. She said the Fourth Amendment requires it, because reasonableness has no time limit. You cannot evaluate whether a use of force was constitutionally reasonable by looking only at one frozen moment, stripped of all context. That is not a legal analysis. That is a magic trick, and the Supreme Court just made that trick illegal. Kagan drew a direct comparison to the earlier case of Plumhoff versus Rickard, where a high-speed chase lasted 5 full minutes before a shooting occurred. The court in that case correctly looked at all 5 minutes of reckless driving to understand whether the final use of force was justified. Barnes v. Felix extends that logic universally. If you want to know whether something was reasonable, you have to watch the whole movie, not just the final frame. Now here is the part that matters most directly to you as a gun owner, and it is the part that almost nobody is talking about. This ruling does not just protect citizens from bad police shootings in some abstract sense. It directly strengthens your Second Amendment rights in a way that has never existed before. Here is why. When you carry a firearm legally, your interaction with law enforcement is fundamentally different from a non-carrier's. The moment an officer sees that you are armed, even legally, even with a valid permit, even with your hands on the wheel and your voice completely calm, the perceived threat level in that officer's mind often spikes. Under the old moment of threat rule, if anything went wrong from that point forward, your legal carry status could actually work against you. The gun in your holster became evidence that the officer had reason to be afraid. Context did not matter. Your compliance did not matter. Your permit did not matter. By throwing out the moment of threat rule and replacing it with what courts call the totality of the circumstances standard, the Supreme Court has reaffirmed something that should have been obvious all along. Context matters. Your conduct matters. The officer's conduct matters. Everything that happened from the moment those lights flashed in your rearview mirror is now legally relevant. If you were calm, if you were compliant, if you were doing everything right, the court is now required to see that. They cannot fast forward past your 3 minutes of perfect compliance to reach the 2 seconds the officer got scared. This leads directly to a concept that the Supreme Court introduced into the national conversation with this ruling, a concept called officer-created jeopardy. It is the ghost that has been haunting police accountability cases for decades, and Barnes versus Felix just let it back into the room. Officer-created jeopardy is exactly what it sounds like. It describes situations where an officer does not stumble into danger. They manufacture it. Roberto Felix did not find himself hanging off a moving car by accident. He jumped there. He chose to put his own body in a position where any movement of the vehicle would immediately become a deadly threat to his life. Then he shot his way out of the situation he created. For years, defense attorneys for officers in situations like this have argued that none of that self-created danger should matter. All that should matter is that at the final second, the officer felt threatened. The Supreme Court just said that argument is finished. But here is where the story takes a turn that every gun owner needs to sit with. The Supreme Court raised the officer-created jeopardy question, and then they deliberately left it unanswered. They sent the Barnes case back down to the lower courts and said, in essence, figure it out using the full context. They did not declare that officers automatically lose the right to use force when they create the danger themselves. That question is still open. We are in what legal analysts are calling a landmark transition period, a space where the old rules are dead, but the new rules are not yet fully written. That uncertainty is not a reason to panic. It is a reason to be prepared. Now, critically, this was a 9-0 win. But it was not a simple 9-0 win. There was an important concurring opinion written by Justice Kavanaugh, joined by Justices Thomas, Alito, and Barrett. These 4 justices agreed completely that the moment of threat rule was wrong and needed to go. But they wrote a separate opinion specifically to send a message to lower courts about how the new standard should be applied, and gun owners need to understand what that message was. Kavanaugh wrote at length about the genuine dangers that officers face during traffic stops. He described the unpredictable nature of roadside encounters. He reminded courts that what looks like a routine stop can escalate without warning, and that officers must make life-or-death decisions in fractions of a second. He even noted that a stop for a broken taillight could involve someone with genuinely dangerous intentions. His message to lower courts was clear. Yes, look at the full timeline. But do not forget that officers operate in high-stakes environments where split-second judgments are sometimes unavoidable. Why does this matter to you? Because the totality of the circumstances standard is a double-edged sword. If your behavior throughout a stop was calm, cooperative, transparent, and lawful, the new standard works powerfully in your favor. But if you were argumentative early in the stop, if you made sudden movements before any command was given, if you failed to notify the officer about your firearm, all of that early behavior is now fair game, too. The court looks at the whole movie. That means your first 30 seconds on camera matter just as much as your last 30 seconds. So what does this mean for how you actually behave during a traffic stop? Here is what the totality of circumstances standard demands from you in practical terms. The moment an officer approaches your window, your goal is to create an unambiguous record of calm, transparent compliance. Keep your hands visible on the wheel before he even reaches you. When he arrives at your window, notify him immediately and clearly. Say it simply. Officer, I have a legally carried firearm. That is the most important sentence you can say. It removes ambiguity. It demonstrates good faith. And under the Barnes standard, courts will now weigh that transparency when evaluating the reasonableness of everything that follows. From that point forward, describe your actions out loud as you perform them. Before you reach for your license, say, I am now reaching for my license in my back pocket. Before you open the glove box, say, my registration is in the glove compartment. May I reach for it? This is not about being theatrical or nervous. It is about creating a verbal record that courts can now use to evaluate your compliance in full context. Every word you say, every movement you narrate, becomes part of the totality that a judge must now consider. And if an officer begins giving you contradictory commands, get your ID while simultaneously saying, don't move, there are 5 words that you need burned into your memory. Say them calmly, clearly, and loud enough to be captured on any recording device present. I am trying to comply. Those 5 words do several things at once. They create an audio record of your intent. They highlight the chaos the officer is creating. They define your movements as attempts at compliance rather than threats. And under the new Barnes standard, they anchor the entire totality of your behavior as non-threatening from the outset. A court looking at the full context of that stop will hear those words and be required to weigh them. This ruling affects the 2nd, 4th, 5th, and 8th circuits, covering tens of millions of Americans across states including Texas, Louisiana, Mississippi, New York, and Connecticut. But its influence will spread far beyond those circuits because unanimous Supreme Court decisions carry enormous persuasive authority even in jurisdictions not directly bound by them. Police departments across the country are already beginning to grapple with what this means for training. Officers will need to be trained to issue commands that are clear and sequential, not rapid-fire and contradictory. They will need to document the full context of encounters, not just the final moments, because courts will now scrutinize the entire sequence of events. Departments that fail to retrain will find themselves exposed to legal challenges they cannot win under the new standard. For the Barnes family, the ruling means that the case goes back to the 5th Circuit with a direct instruction from the nation's highest court. Look at everything. Look at the fact that the stop was for a toll violation, not a violent crime. Look at the fact that Officer Felix jumped onto a moving vehicle against every principle of his training. Look at the full context. Whether that ultimately results in a finding of unconstitutional force is still for the lower court to decide. But for the first time, they must actually look. They can no longer hide behind 2 seconds of fear to justify 5 minutes of recklessness. There is one more thing you need to understand about where this goes from here. The Supreme Court's opinion explicitly flagged the officer-created jeopardy question as unresolved. That is not an accident. When the nation's highest court writes a unanimous opinion and deliberately leaves a major question open, it is an invitation. It is a signal to litigants, to lower courts, and to the legal community that the next case is coming, and that when it arrives, the court is ready to answer. The question of whether an officer can recklessly manufacture a dangerous situation and then claim constitutional justification for shooting their way out of it will be answered. The only question is which case carries it back to the Supreme Court and when. Until that answer comes, you are operating in a legal landscape that is more protective of your rights than it has been in decades, but also more demanding of your personal responsibility than ever before. The totality of circumstances cuts both ways, and the court has made clear that your behavior, your words, your compliance, and your transparency are all part of that totality. Constitutional rights do not enforce themselves. The Supreme Court did its part. 9 justices, 0 disagreement, a unanimous declaration that the Constitution does not have a stopwatch, that it applies from the moment the lights flash in your rearview mirror until the moment the encounter ends. Now the work falls to you. Know your rights, know your responsibilities, know the 5 words, document every encounter. Stay calm, stay visible, stay verbal, and stay compliant. Your rights just got stronger. Make sure you are strong enough to use them correctly. Here's the thing the mainstream media is completely ignoring about this ruling. A 9-0 decision does not fit the narrative of a divided America. It does not generate outrage clicks. It is a quiet surgical correction of a legal error that existed for decades, and quiet surgical corrections do not trend. But just because it is not trending does not mean it is not transformational. 9 justices who agree on almost nothing looked at the moment of threat doctrine and unanimously called it constitutionally indefensible. That kind of consensus does not happen by accident. It happens when a legal error is so structurally wrong that even the sharpest ideological differences cannot obscure it. The practical takeaways deserve to be said clearly. Every encounter you have with law enforcement now carries legal weight from the very first second. Build your compliance record early and build it out loud. Notification is no longer just a formality. It is a foundational act of self-protection that establishes your transparency from the moment of first contact. Your words are evidence. Narrate your compliance. State your intentions. Create a record that tells the complete story of who you were during that stop. Document everything afterwards. The commands, the order they came in, the contradictions, your responses. Under the totality standard, those details can determine the outcome of a legal challenge. Barnes v. Felix is more than a case about one traffic stop in 2016. Ashtian Barnes did not get to see this ruling. His family fought for years through courts that refused to look at the full picture. The Supreme Court finally made them look. That does not undo what happened, but it changes what happens next for every law-abiding citizen who carries a firearm and wonders whether their constitutional right will be used against them in the worst possible moment. The chronological blinders are off, the invisible shield is broken, the court must now watch the whole movie. Do your part, stay calm, stay verbal, stay compliant, stay informed, and that movie will tell the story of a citizen who did everything right. 9 justices, 0 disagreement. Your Constitution just got its teeth back.